Good afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge. My name is Jenna Labor, and I will be your host as we explore the dynamic world of Don Keenan's trial philosophy, the cutting edge. Those of you joining us live this afternoon have the opportunity to ask questions and interact with our speaker. If you have a question, please type it into the comments section below, and we will be sure to address it. Episodes are released each week following the live broadcast, so be sure to hit that subscribe button and click the alerts icon so you make sure that you don't miss an episode. Today, we have Scott Distasio with us out of Tampa, Florida, and he's going to be talking about failures in nursing home and assisted living cases. You all know that as edge lawyers, we bring cases because of a breakdown in the system, of a failure that is larger than what happened to just our client alone. What do we always ask? What happened to our client? That can happen again. And how do you empower that jury to make the decision to protect the community, right? That's always our goal. I am excited to hear from Scott how he does this in nursing home and assisted living cases. This is an area of law that I am less than familiar with. And I know we've had David Hoey on the podcast before talking about some nursing home things, but this is real boots on the ground, practicing edge lawyer stuff that we're going to hear about today. I'm very excited. So we'll put Scott's information, contact information in the description box below so that if you have any specific questions, maybe you practice in Florida and want to bend his ear or work on a case with him, you can feel free to do that. Scott, I'm going to turn it over to you. Tell us about these failures in nursing home and assisted living cases so that we can run our cases the best we can for our clients.
Absolutely. So I think, what we need to do is start from the question of why do we lose cases? And it's always because we're focusing on the wrong thing. And what the defense in a nursing home or assisted living facility case wants you to do is focus on the medicine, focus on the standard of care, and focus on the limited issue of what was or was not done for that particular plaintiff in the nursing home. And when we do that, we end up in a position where the jury is focusing on something they may not care about. And so what you need to do is think about, what does the jury actually care about? And in order to do that, you have to say, well, what is a jury typically thinking when they're analyzing your case? And the first thing that goes through their mind is what Don Keenan would call negative attribution. And what is that? That's the idea that I'm not going to be in a nursing home. This isn't going to happen to me. Or if my loved one is in a nursing home, I'm going to be checking on them. I'm going to make sure this doesn't happen. And so in that situation, that's what those jurors are focusing on. And if you don't, shift their focus. And so you have to know and understand that, and you have to come up with ways to demonstrate, yeah, this might not happen to you, but this could happen to your loved one. If your loved one is in the facility, you may think checking on them is going to make a difference, but here's why it isn't. Another thing that jurors are focusing on is tort reform, right? There's so many frivolous lawsuits out there, according to the media, according to the propaganda. And that's what they're focused. Is this a frivolous lawsuit? When you make it about the individual harm, often they don't see the bigger picture, why this is really happening. Next there's compassion fatigue. We have in our society death, and on TV we have wars in Israel, we have wars in Ukraine, we have crime being focused on, and this is just another bad outcome. Why should they care? And so this is what's running through the jurors, or the potential jurors' minds. And if you don't make the focus the defendant and the defendant's conduct, then they're not paying attention. They're not seeing how it could harm them. And so what you want to do is take the focus off of the plaintiff, take the focus off of your client, and make the focus about the defense. And that doesn't mean the medicine. You want to take the focus off of the medicine, and otherwise it just becomes a battle of the expert, the battle of the experts. So what I'd like to talk about is how you do that, and the things and the steps to do that. So the way to do that is to start at the beginning with Don Keenan's concept of case selection, right? And, if somebody falls in a nursing home, that's a single event case. How do you turn it into more than just that single event? So you go to the case selection criteria and you look at the three things that are important, that if you focus on them, you're taking the focus off of the conduct of the plaintiff, and you're focusing on A, the system values of the defendant, and B, how the jurors, the potential jurors, are going to see that could harm other members of the community. And so that's the lens that I look at when I'm looking at a case.
What kinds of questions do you ask your client when you're doing, or your potential client, let's say they call you up and you're looking through some of this case selection stuff? What questions do you ask and what information are you looking for?
So, there's a whole host of types of cases, right? I mean, I can list off, falls, pressure sores, medication errors, physical abuse by staff or other residents, when residents wandering away from the facility, failure to send someone to the hospital, infections, sepsis, dehydration, weight loss, malnutrition, hygiene. So these are the things that we're looking for, right? In general. If you talk about dehydration, weight loss, malnutrition, hygiene, those are not things that even though they're not doing those things, they're not producing an actual real injury. But those are things that, as you're interviewing your client, they're going to upset a juror if they're not taking care of the resident, if the resident's dehydrated, if they're losing weight, if they're malnourished, if they're not, hygiene isn't being taken care of. So you want to start with those first categories. What is the injury? Is it a real injury? Is significant enough that the potential juror is going to care? And then as you're talking about the injury, you want to be finding out about those other things. For example, you have somebody and you get a phone call. Hey, my family member fell at the nursing home and what was the injury? They fractured their hip. You have a significant injury, but who cares, right? I say that in with all due respect to that individual. At the end of the day, a juror is going to be saying that person's old, they fell, people fall, they fractured their hip. So what are the things that are going to turn that single event into a something that a juror is going to care about? Well, first, as you're going through the questioning, you want to be asking about, dehydration, weight loss, malnutrition, and hygiene. Absolutely, because if you can find other factors, you can also create a situation where it becomes more than the fall. But you also need a detailed history of that client, that person, and what is their fall history? Were they falling before they came into the nursing home? Did they fall while they're in the nursing home? Other times before the hip fracture. And so those become important because you need to take, for example, a fall case outside of this is just one event. And so what we look for is patterns in fall cases. Were there multiple falls in the nursing home? And if so, where did they occur? Did they occur in the bedroom at 3 o'clock in the morning? If there's 3 falls in the bedroom at 3 o'clock in the morning, and then the 4th one, we have a hip fracture, now you can say to yourself, there's a pattern. And then you can say, was this foreseeable? Mm-hmm. Is there something that could have been done based on that pattern to have prevented this event? And now you've turned, somebody fell in the nursing home and broke their hip, into there's a system failure because this was foreseeable. There's things that could have been done to prevent it. So what can you do in that situation to prevent it? I happen to have a long history of doing these types of cases. I was a defense lawyer defending them for 10 years, and then for the last 24, I've been suing them. So I know a lot about how these things work. But what happens when somebody comes into a nursing home is they have to have a seen by a doctor, and then they have to be a care plan has to be put in place. And that care plan has to be have interventions for that person. And then when there's changes in condition, they have to update the care plan, and they have to put interventions in place to deal with that. And then they have to document that they're actually doing it. So going back to this fall case, you have somebody falling. You're going to be interviewing that client. Tell me about the falls. What happened? When did they call you? Did they tell you about a care plan? Did they update the care plan? Did you see them implementing the things that they were supposed to be doing? Often the client doesn't have answers to those questions, but they can tell you there was a fall. It happened at 3 o'clock in the morning, 2 or 3 times, and then they fell again and they fractured their hip. So knowing what a nursing home is supposed to do in that situation creates a system, and then you can look for the failures in those systems. So what is a nursing home supposed to do when somebody has had those problems? They're supposed to say, what can I do to prevent this person at 3 a.m. from falling? Are they getting up to go to the bathroom? Put a toileting program in place where at 2:30, somebody comes into the resident's room, takes them to the bathroom, and then puts them back to bed. Because these are people that are frail, they have dementia, maybe they can't walk on their own very well, they need a walker, it's dark. So that's an example of, by interviewing the client and identifying a pattern and then saying, well, it's foreseeable that they're going to get up at 3 a.m. or sometime, and then how do I prevent it? Now, I just know, because I've been doing this so long, that there are experts that will say that nursing homes have a duty and obligation to put a toileting program in place for residents who need to go to the bathroom in the morning. They should be putting it on the care plan. The intervention should be there. They should then, in the record, have a place where they document that they're doing it. So then you order the chart, and you find out, and what you'll find in these nursing home cases is they continue to fail to do those things. And then you got to ask yourself why. And the why is pretty simple. I mean, you start with, again, case selection. Don would say, how does the defendant's conduct impact random victims? Why should the community care about the outcome? And are there system failures that will lead to this happening again, right? So in asking those questions, you then begin to see the case as we kind of described it and begin to flesh it out. And then you have to start looking at the motives for what happened.
I imagine, part of that, what you're just talking about now, is so that you then can empower the jury to make a decision that not only compensates your plaintiff, but also potentially creates change and a better standard of living, quality of life for other folks in nursing home and assisted living facilities. Because you're not only just giving money to one person because of one thing that happened, but you're addressing the fact that they don't have the proper care plans in place, or they do and they look awesome, but they don't actually implement them, or whatever other problem that's really systemic problem is really going on.
Exactly. And you use that word, empowering the jury. Absolutely. So how does the defendant's conduct impact random victims? So, well, now you have, after interviewing the client, you have this pattern of events, you have a foreseeability, and you have a medical nursing reason about how it can be prevented. That's the start, right? It's not the end, because if all you do is that, you're still just focusing on your client. You're still just focusing on the medicine. You're still just focusing on the standard of care and the battle of the experts, right? So how do you now take that, because you found that pattern and that system failure, and magnify that into corporate conduct? And that's the kicker that takes these cases from, you're just standard run-of-the-mill, old person died, let's give them, $50,000 for a fractured hip, or who cares, and it turns it into, this corporation is harming people, and I don't want them to harm anybody else, and I am going to give this person full value for what happened, and becomes a $1 million case. And so, again, I mean, it sounds complicated, but at the end of the day, it's going back to the basic principles of case selection and motive. So how does the defendant's conduct impact random victims? Well, in this particular circumstance, we're using as an example with the falls. Well, if they're not care planning, is it happening to other people? How many falls are in the facility? Can I get the charts of those other residents with the names to protect them from HIPAA, to see if they're not toileting other residents? They're not answering call bells for other residents. Then we can see how the conduct can impact other random victims, other people's loved ones. Hey, this could happen here to my loved one. It's not just a one-off where they failed to chart it. It's happening all over. Why should the community care about the outcome? I guess is the second case selection criteria. Well, again, you want to focus on, these are people in a nursing home that are frail and elderly, and if the care is not provided, then it might not be provided to other people that are entering those nursing homes. And then lastly, obviously, is the system failure. Are there system failures that will lead to this happening again? And so, number one, how does the defendant's conduct impact random victims really falls back to, what's the system failure, and what's the motive behind that? And what we end up with is the system failure for corporate conduct. What is it? So you have the system failure for your individual case, which is the fact pattern we described, identifying the foreseeability that this person's going to fall and fracture their hip, and knowing medically what could be done to fix that, right? But to level it to the system failure on the corporate level, you have to understand the motivations of these corporations. And that motivation is money, the bottom line, profit. And so what they do is they hide behind, we're barely making any money. And the way they do that is that they get paid a flat fee. And Medicare is generally the payor. And that flat fee is based on the amount of care that resident needs. And there's something called an MDS, minimum data set. And that nursing home has to score each resident based on that resident's minimum data set. Do they have a feeding tube? Are they bed bound? Do they need someone to help them to feed them? Because all these things require more care. So by scoring them, getting the highest score possible, then they get paid flat fee for that resident more, right? So they want to score these residents as high as possible. And so they are publicly saying, give us your most debilitated people, your weakest people. Come, we're the professionals, we're the experts, we can take care of those folks. And then they come into the facility, they score them real high, and they're getting paid a flat fee that is very, very high. And the implication from that is that they're going to increase the staffing levels to provide the care for those individuals because they're getting paid a higher fee. But what you'll see is that never happens. The facility has minimum staffing levels. Every state generally has a minimum staffing level. And the facility staffs the facility at the minimum staffing level, but they score all the residents for the highest.
Yeah.
Okay. And so there's your profit motive. And so you have to focus on, okay, you met the minimum standards, but you have to design a series of questions that demonstrate, when you're talking to the staff members, what do you have to do? I have to turn and reposition people. I have to feed people. I have to do these things. And do you have enough time to do all of that? No, I don't. How many people do you care for? I care for 30 people. And, it becomes obvious when you start doing that they're not staffing for the increased level. And so the issue is understaffing. It's staff turnover because they pay very low for these residents, for the staff members, and they turn over and they constantly have new people, and then poor training. And so those are the things that you have to focus on in order to kick it from this individual case system failure, which you still need, and then the corporate system failure, which is going to demonstrate the jury that this is just all about money and that they're purposely denying care by understaffing the facility to make more money. And it's not all of them. There are some that do the right thing, but often when you see these bad outcomes, that's what's happening.
Do you, when you're talking to a jury or when you're running this by focus groups, do you talk about analogous system failures? So like if I've never had any experience with a nursing home or assisted living facility because my parents are young enough and I wasn't, quite aware when my grandparents might have been in them or whatever it may be. And so I'm like, this is just flying over my head and I'm having a hard time understanding it. What kinds of examples do you give people like that for analogous system failures to help them understand what this might look like if another type of corporation did it?
Yeah, I mean, the truth is that nursing home is a unique set of circumstances because of the flat fees and the way that they do it. But yeah, I mean, you can talk about hospitals and people being in hospitals and getting medical care in general. And, are you getting the care? A lot of jury selection can be about, tell me about your experiences with being in the hospital. Do they provide, and you'll get people telling you about, the care that isn't being provided and that they feel like they're in an assembly line. You going to the doctor's office and feeling like a number. But to be perfectly honest, I don't know that there is a situation where there's a business that is set up under this model to make a great analogy from the corporate standpoint. But what I do know is that if you focus on those elements, the jury gets it. You can't overcomplicate it though. And the way you simplify it is you have former staff members. And what you do is by the time they give you the names of the employees, and at least in Florida, in most states, you probably can't talk to the current employees without taking their depositions. But the former employees are free game in most states. You can go track them down. So you ask for those former employees. and you ask for their contact information. And by the time you get it, it's a year to 3 years into the event, and there's mostly former employees. And you send out an investigator and you interview those folks, and you'll invariably find 1 to 5 people who are willing to tell the truth about what happened. You get them stigmatized, and then you meet with them and you get their courage up to do the right thing, and then you put them under oath. And they talk about how it's understaffed, how they don't have time to do their job, and how they want to do the right thing, but they just can't. And they often will talk about not being able to do the right thing for your client. And so instead of focusing on other analogous situations, I think that, at least in the nursing home cases, I think it by focusing on the conduct of the facility and simplifying all the complicated scoring issues, instead focusing on the staff and their inability to do their job in your case, I think the jury gets to see that picture.
Right. And then you could analogize it to, I mean, to me, when you're talking about it, I'm thinking, and I don't even have kids, but I'm thinking like childcare facilities, you know, what would happen if a childcare facility was understaffed? What does happen when childcare facilities are understaffed?
Right.
You know, like what about in the airplane industry, you know, if you don't have enough ground crew people, or, you know, even flight attendants or whatever, and somebody misses a checklist, or these are all places where when there's understaffing or high turnover, other people's lives could be put in danger. And we can see, you know, maybe I've not dealt with the nursing home, but I've been on an airplane, or maybe I have a child and I'm like, oh, I understand that. I understand why that is such a huge problem. And while I may not care that Betty Smith at 95 years old fell and broke her hip, I do very much care about the larger, bigger picture of that system failure, even though we're talking about it in that nursing home context, because I see how it could apply in other places. And I want that message to be sent, right? Even if in Washington, we don't have punies, but you can still kind of imply that message needing to be sent to other businesses that may think that it's okay to operate this way.
Right. Absolutely. And those types of analogies you just described, I think, are perfect, especially the childcare systems. And what I meant by there's nothing to analogize it to, not that there aren't those things out there. It's just that I don't know of another industry, and maybe it's because I've been doing this so long and I'm just jaded, and I think so badly of most of the nursing home operators in this country. I don't know of another industry that purposely, and I say this directly, purposely understaffs their facilities, knowing it's going to harm somebody to make more money. And so I think you're right from the daycare. What if we were doing that in daycares? But they don't, right? I mean, can you imagine if they did, the outcry that we would have in this country? And yet, for some reason, this happens on a daily basis in nursing homes, and we don't have that outcry. And I think it's because we've, in this country, outsourced the care of our adult loved ones, where we have not outsourced the child care as much. The child still comes home to our house, we're still interacting. But in the nursing home environment, people have gotten to the point where they're living in these facilities full time, and there's just no focus on culturally, society, the harms that are being caused in this environment.
It is a difficult, and I think talking culturally is important because we don't place as high a value on the elderly in our culture that some other cultures do. And because we are so focused on production, and we see the value of life through the lens of what are you doing to contribute to society, or what are you producing, or what are we benefiting from you. And as you age, that just inevitably becomes less and less. And so by framing it in this system failure, this larger breakdown, and analogizing it to different things or whatever it may be, or imagine if this happened over here, imagine if it happened over there, how terrifying it would be. You kind of take it away from, you're never going to change with one case an entire mindset about a demographic. You're never going to. But if you bring it away from, as you spoke even at the very beginning of this talk, bring it away from that individual person and bring it to the larger, bigger picture, so that the jury can say, yeah, you know what? It's not really whether I think, I'm not going to change my mind that elderly people are now just like these valuable members of society, but I am going to rethink whether or not I care that they're taken care of appropriately and that corporations are doing what they're supposed to do, because that could potentially affect me. So that's
absolutely. And while I agree with you from a societal standpoint that our society is more focused on productive people, whereas some other cultures are focused on their elderly. I absolutely agree with that. But I don't think that means that a jury in this country cannot see the harm and that they cannot compensate for it. And I also don't think that we don't care as a culture. I think that we're so busy and distracted with our productivity. We're so busy and distracted with entertainment that we don't see it happening because it's not our focus. So if you were in an Asian culture, the focus is often on the elderly. So they would see it because that's their focus. Our culture not seeing it because it's not their focus doesn't mean that they don't care. It doesn't mean that they wouldn't be outraged if they knew. It just means they don't know. And I look at my job as shining a light on it so that they do know. I mean, if you look at this country, and I mean this analogy with all due respect, if you look at the struggle of the Black community, the African American community in this country, you will see that there was a time period where people didn't care because they didn't focus on it. And you saw George Floyd and the events that happened with George Floyd shine a light on it in a way that people cared. And was it really happening? I'm so busy in my life. Maybe that didn't happen, maybe it did, but now here's a video of cops kneeling on this man until he dies, and it's in your face, oh, this is really happening, I care, and look what happened. And what I see in the nursing home industry and with our people, elderly people, is the same kind of thing. People don't know it's happening. They're focused on their everyday life. But if you take a light and you shine it on it and you show what's really happening, they care, they do. But it's our job as trial lawyers that handle these types of cases to do that, to shine the light on the real motivation, the real reason this is happening, and what the bad outcome is. And so that's how I kind of look at what I do on a daily basis, because a substantial part of my practice is nursing home abuse and neglect and also medical malpractice.
Mm-hmm, mm-hmm. Yeah, that's a really good point, that we just don't see it, so we aren't aware of it rather than not caring so much. What other failures do you see? So we talked about understaffing. What other things that do you see in your practices that leads to this type of injury, kind of the foreseeability aspect of it?
Yeah, absolutely. So the other thing that happens, and it is really egregious in the state of Florida, but it happens all over the country in various different ways, is that the nursing home wants to claim that they're poor. We're getting paid a flat fee, and look at our balance sheet. We're barely making money or we're losing money. And it's true when you look at their balance sheet, that's true. So look at these greedy trial lawyers. They're just taking advantage of us. We're doing the best we can in this situation. to provide the care, and these lawsuits are just taking money away from us. So in the right case, in the right defendant, what we look for is, why is that balance sheet the way it is? And there's a concept that's called tunneling, and it's the illusion that profits are costs. And you're like, what?
Yeah.
So what the nurse, if you go to a hospital, they have physical therapists, occupational therapists, nurse, respiratory therapists, and they're often all employed by the hospital. If you go to a nursing home, in most states, the only people employed by the nursing home are the nurses and the nurses' assistants. Everyone else, there's a contract that is created and a separate company is created, and there's a price for that service. So physical therapy, occupational therapy, and speech therapy will be a company, and they're charging a price. Well, guess who owns that company? The parent company of the nursing home. And then there's a management company. And often the management company is owned by the parent company of the nursing home. And then there's real estate. And who owns that? It's another company. And the parent company is owning that. Now, there's various models. Sometimes they're not all owned by the same parent company. But what they're doing is, if it costs X number of dollars to own all of these aspects outright in a nursing home, if we split them up and then charge outrageous fees for those services, and everybody's doing it, it becomes the standard that the cost of a management company is 5% of gross revenues. Well, the standard to have this company provide physical therapy, occupational therapy, and speech therapy is X number of dollars. But it doesn't cost that much to run those places. So those are turned into costs that are sucked out into these other companies. And then the balance sheet looks like they're breaking even or losing money. But in reality, those are actually profits, because 90% of the time those fees are going back up to the shell company, and then the shell company up top is calling them profits, because that's what they are, that should have been profits for the nursing home. And I'm a capitalist. I believe in profits. But when you're denying care by hiding your profits and making outrageous profits while people are dying, I got a problem with that.
That's wild. That's
right?
wild. Yeah.
So in the right case, you come up with different theories. You have piercing the corporate veil. You have breach of fiduciary duty and aiding and abetting the fiduciary duty. You have, in some states, joint venture. In some states, alter ego. And you plead in the right case, this becomes very expensive. You have to have the right idea and the right nursing home and the right plaintiff. But you plead all of those, you get all those contracts, you demonstrate this. And I got to tell you, the times that I've done that, and gotten it all lined up, the time that I'm about to, and I've got the balance sheets, I've got all the contracts. When I've got the deposition set of the head guy, I get a phone call and they settle because they don't want this out in the public. And so that's the other area you can focus on, but it's time consuming. It's expensive. They fight tooth and nail because they don't want to give it to you. And some judges will hide that, will agree that that's not part of your case and say it's not relevant. And so, you know, you have to pick the right case to make that case.
What do you look for? This is a two-pronged question. What do you look for to see if it's the right case? And second, what do you ask for to find out that structure? Because I imagine that if you ask for something like what's your corporate structure, then it's not going to come out. It's going to take more than that.
Right. So the first thing, what's the right type of case? It's generally a case where there is just significant suffering on behalf of the individual. You have and overwhelming obvious breaches of the standard of care. You have, for example, somebody who comes into the nursing home and they are bedbound and they develop a pressure sore, and there's no turning and repositioning. When you have, in order to avoid a pressure sore, you have to turn and reposition somebody who's bedbound every 2 hours. And if you don't do it, the pressure builds up and the skin begins to deteriorate. You have a case like that, and you have the skin breakdown. There's photos of it. They get sent to the hospital, and when they get to the hospital, they're in a diaper, and the diaper has foul smelling feces that is dried and rotted and urine smell. And the hospital takes the time to document that with photos and a description. And then they determine that that wound is infected, and they do several surgeries on that person, and then they end up dying. I mean, that's an actual fact pattern that I see from time to time. That's the kind of case that those facts are going to outrage a jury if you can demonstrate the system's failures. And that's the type of case that I would want to be looking at, the higher level corporate conduct, and are they sucking the money out through these ancillary companies? And then how do you do that? I mean, I have a standard set of requests to produce interrogatories that I send out in every case, and they object to every one of them. But do I then go follow up and ask them to give me those things? Medicare has a cost report, and Medicaid in your state may have it as well. And they require certain disclosures. And if you get those documents from the federal government, or you can Medicaid the state government, they often show the ancillary companies and require the documentation of any company that is related to the nursing home. And so by getting that document from Medicare, the cost report, and identifying the related companies, and then seeing what care they're providing, and it often, those things will show what they're paying. And then from there, you can then hire experts that can talk about these things.
Mm-hmm. Okay, that makes sense. Do they ever plead anything in their answer that you use? Okay, let me see if I can say this. So like, say they're objecting, they're like, you're not going to get this information, and you move to compel. Do you ever use anything they've pled in their answer as a reason to be able to do this? For example, we are plea of poverty or something like that, or, do they put anything in the record where you can say, well, Your Honor, they have said that they're too poor to be able to do this. Therefore, I have to be able to explore that, or vice versa, be able to gag them on that issue, because otherwise they risk you getting into that discovery.
Absolutely. So some judges, when you just plead it because it's in your pleading and that's what you're supposed to prove, will give you the information. Mm-hmm. But a lot of judges will say that's not relevant, even though you've pled it. In my opinion, they're wrong. But the judge just says there's not enough here. So you have to get them to make statements that demonstrate that they can't afford it, or you get evidence of the understaffing. Like I said, the nursing home staff members that are saying they don't have time, and that extra information will often convince the judge to give you the corporate discovery. But if you're alleging understaffing, and then you're saying the understaffing is because of this corporate profit motive and they're sucking the costs out, sometimes that's not enough. But when you start to show the understaffing, and then maybe you have the administrator saying that, we didn't have the financial resources in a deposition, then, well, judge, I need the documents to prove that's a lie, right?
Right. Okay, that makes sense. All right. Let's see. Have you had any, well, let's talk about this. Spreading the tentacles, right? That's a big thing we talk about. So
Yeah.
when you're dealing, there's various types of these facilities. Some have one home, or one building, and some are national and have them all over the place. How do you use that size to, I guess, increase the danger to the community? And do you look for that? Do you care about that? Does that matter to your focus groups and your juries?
So it absolutely matters, absolutely care about it, but it comes down to the proclivities of the individual judge and how the nursing home chains are set up. Some judges feel that, what's going on in other facilities is totally unrelated, and you can't get past that because of the proclivity of that particular judge. But assuming that you have to look at the corporate structure of these nursing homes. And it always amazes me, for example, here we have a hospital chain called Baycare. Every hospital, Baycare here, Baycare there. Go to, at least in the state of Florida and in most states, there is no corporate name associated with all these facilities. They all have individual names, and they're hiding that corporate structure, and they're pretending that they're an individual entity. So it's often hard to get that corporate system, well, they're doing this in this facility, and that's relevant to our facility, because they're claiming they're totally unrelated, right? This is one license holder and it's one company. And then this other nursing home is another license holder. It's a separate company. And so why should what's going on over here have anything to do with what's going over here? And while, yes, I would love to be able to do that, often it becomes too complicated to show that corporate structure in a way that the judge will find that it's relevant, because of the way that they've set up all these shell companies.
And does a judge prevent you from just asking what maybe 30B6 witness? Do you also own this facility and that facility? Or do they say, no, do they deny it sometimes, or judge prevent you from asking?
Well, the answer is there is no 30B6 deposition of the shell company, because you often can't bring the claim against that shell company. You end up bringing your claim against the license holder, and you end up bringing your claim against the management company, and they can accurately deny that they're related, right? Because, we're not related. You never get up high enough in the chain often to that corporate company that's really controlling everything, unless you get to the point where you're pleading these alternative theories, like piercing the corporate veil, like breach of fiduciary duty, and aiding and abetting that breach of the fiduciary duty. So in the right situation, you can do that. But again, you have to have the stars align, and you have to be able to get all of those other companies involved. Some states will let you do it. Florida, in the infinite wisdom of the Florida legislature, will not. We actually have a statute that was politically motivated, in which the legislature agreed that we can only sue the license holder and the management company, and that if we're going to sue some other company, we have to file the lawsuit against the license holder and the management company, and then take discovery and prove during that discovery that that corporate entity up here is really running the show. And it becomes very difficult because they object to everything, and you have a difficult situation to get that proof. So it depends on your state. there are some states that will let you, and in previous years, I don't know when the statute was changed, maybe 5 or 10 years ago, we used to do that, name all these companies. But unfortunately, at least in the state of Florida, the legislature has created statutes that seem to protect the nursing homes as opposed to protect the citizens and the elderly. It's very upsetting, actually.
Yeah, that is. Do you ever run into an admitted liability scenario where they admit so that they to intentionally try to prevent you from getting discovery into all this stuff, or is that just too wild? They would never do that.
Twice.
Okay.
I've been 34 years.
Yeah. I mean, I feel like that's what I would do if I were the defendant. I'd be like, I did it. That's, let's talk about damages, and then it cuts you off at the knees.
They have this knee-jerk reaction to defend themselves.
Yeah.
And it's in my mind shameful. There are experts that are willing to say that that it's okay that it's not documented, that I believe that it had to have happened, that this is just a poor outcome, and that medically was going to happen anyway.
Yeah, they did all they could, or the bare minimum, anyways, that they could.
And they believe that that's the better route than to admit liability. Yeah.
Mm-hmm. Interesting. Well, and on the one hand, that's good, because then you do get discovery into some of these things that you might not, because we run into a lot of admitted liability on different types of cases, and that it's difficult to frame that in a way a judge will allow more expansive discovery. Mm-hmm. So on the one hand, that's good. On the other, it's difficult. How did you get, I mean, we only have a few minutes left, but talk to us about how you kind of started doing nursing home stuff. Did it stem from you defending them in the first place, or kind of talk to us about that?
Yeah, absolutely. So I came out of law school and became a medical malpractice defense lawyer. And this was in the early 90s. And the law firm took on a defense of a nursing home case, and quite frankly, nobody in the firm wanted to do it. So the partner I worked for decided he would do it, and then he gave it to me because he didn't want to deal with it. And so very early on in my career, that's what I was doing, is defending these facilities. And I did that for 10 years and ultimately became the partner in charge of a nursing home defense practice that, spanned the region of Tampa Bay and further, and defended most of the corporate chains that providing care in the state of Florida. And quite frankly, I just got tired of it. And I felt like I was a cog in the wheel of society to allow these companies to deny care to make money. And I wasn't going to do it anymore. So I basically fired all my clients, walked out, and helped start a plaintiff's personal injury firm. Was there for a while, and then left in 2007 to open up my own law firm. And quite frankly, I thought, we'd do some car crash cases. It's not as time intensive, but everybody knew I'm the nursing home and medical malpractice guy. And so they started sending me cases. And so for the last 24 years, I've been suing them.
Well, we are happy to have you on our side. I always think, if I were to do it over again, not that I would ever want to necessarily be a civil defense lawyer, but I think it's valuable information. I mean, it's incredible experience that I think can be helpful. I
would not trade my experience as a defense lawyer for anything. It taught me how to work up a case. It taught me how to work, in a large organization. It taught me how to be organized and how the other side thinks. Mm-hmm. My only regret is I did it for 10 years instead of 5. Well, those extra 5 years meant something. I'm sure there's a difference between what you're bringing to us now than what, you would have had you only done 5 years. There's probably something there. And then tell us about your edge journey. How did you find your way to the edge, and where are you in the edge? I know you're a referring lawyer. That's where we met. Tell us about that. Yeah. So believe it or not, I met Don Keenan in approximately 1992. I was a second or third year associate, and the partner in charge of the hospital medical malpractice department was trying a medical malpractice case, and the local lawyer flew in this big shot from Atlanta to come and try the case. And Don kind of parachuted in, and I kind of participated and helped that case from the defense. And so I knew of Don, but, I didn't have any further contact with him until I had left the defense practice. I had started that other plaintiff's law firm and then had left them, and I was on my own. And right around, 2009, I was wondering whether I'd made a mistake to become a plaintiff's lawyer, right? And looking at all my inventory and saying, I've got to finance all of this, and I got this little case in my repertoire of a gentleman, a young boy that went snow skiing, and on a church group, and he ended up paralyzed. But he did it to himself in my mind, and I saw this book called The Reptile. Picked it up. I read it from cover to cover, and they offered me $10,000, and I put together from that book my rules and put together my opening and my directs and crosses and my closing, and we ended up with $5 million verdict, having just read the book. And then that was, I don't know, around I think the verdict was like 2012, maybe. And then I found that there was this little seminar going on in Chicago, and I showed up with a bunch of other lawyers and kind of reconnected with Don. So that's the process. Yeah, you can read a little bit about it in one of the Edge books.
Awesome. All right. Well, Scott, thank you so much for being here. I just appreciate your time and your insight and having, the experience that you took from kind of being on the dark side, which, sometimes that's a good thing, to bringing it to our side and doing what you're doing. It's really fantastic. And I'm proud to know you and glad to have met you over the past couple of weeks in Colorado with Greg. And also, thank you to our audience. Thank you to everyone who joined us for this week's episode of Fridays with Keenan's Cutting Edge. If you like the episode, give it a thumbs up. There's this algorithm YouTube has. When you interact with the video, it pops up for more folks. So if you found it useful and you think it might be useful to others, click the thumbs up. When it airs next week, I believe it comes out on Monday, feel free to share it with anyone you think it might be helpful for. The next live episode we're going to have is October 11th. And so I have been able to wrangle a few of the referring attorney lawyers to come on to the podcast and chat with you all about what they're learning. And so we'll be having a few live podcasts throughout the fall season. And the first one is going to be October 11th, when Dave Crump will talk to us about his experience as a referring attorney, both in the med-mal context, which is how I was connected with him, and also in others. So I look forward to hearing from him. You'll want to tune in because it's an incredible program, and you'll want to submit your cases after you hear about how awesome it is to be a referring attorney. So thanks again, Scott. Thank you again to our audience. Have a wonderful weekend, and I will see you all next time.